Hi friends, so on the 11th of March 2024, the Home Minister Mr. Amit Shah announced the implementation of the Citizen Amendment Act.
इसकी माइनॉरिटी को और विशेषकर मुस्लिम भाइयों को भड़काया जा रहा है। देश में किसी की भी नागरिकता सीए छीन ही नहीं सकता क्योंकि कानून में प्रोविजन ही नहीं है। सीए जो शरणार्थी आए हैं पाकिस्तान और बांग्लादेश से धार्मिक प्रताड़ना के कारण उनको नागरिकता देने का कानून है और मैं मानता हूं इसमें किसी का विरोध नहीं होना चाहिए।
Which when passed in the parliament in 2019 was vehemently protested and criticized globally and had to be put on hold. But then this was on the manifesto agenda of the BJP and has been announced before the elections which are around the corner. So what is this Citizen Amendment Act of 2019, which is the CAA? This was an act which was passed by the Parliament of India on 11th of December 2019. It amended the Citizen Act of 1955 by providing an accelerated pathway to Indian citizenship for persecuted religious minorities from Afghanistan, Bangladesh, and Pakistan who arrived in India by 2014. The eligible minorities were stated as Hindus, Sikhs, Buddhists, Jains, Parsis, or Christians. The law does not grant such eligibility to Muslims from these countries due to the fact that Muslims are majorities in these countries and do not face any fear of persecution. So, this law, when passed at that point of time, attracted lot of global criticism. The amendment has been criticized as discriminating on the basis of religious matters, particularly for excluding Muslims. The OHCHR called it fundamentally discriminatory, adding that while India's goal of protecting persecuted groups is welcome, this should be accomplished through a non-discriminatory, robust national asylum system. The citizens or the critics basically felt that the Muslims are being segregated and being treated as migrants and not being given citizenship. But then here was a point that basically the requirement was to give documents proving their lineage or their parental details, which was to some extent misconstrued and misunderstood. Commentators also question the exclusion of the persecuted religious minorities from other regions such as Tibet, Sri Lanka, and Myanmar. Our government said that since Pakistan, Afghanistan, and Bangladesh have Islam as the state religion, therefore there is no chance of the citizens there facing any persecution. Now coming on to what is exactly this Citizenship Law of 1950. The Indian Constitution implemented in the 1950 guaranteed citizenship to all the country's residents at the commencement of the Constitution and made no distinct demarcation on the basis of religion. In 1955, the Indian government passed the Citizenship Act by which all people born in India subject to some limitations were accorded citizenship. The Act also provides two means for foreigners to acquire Indian citizenship. That is, people from undivided India were given a means of registration after 7 years of residency in India. those from other countries were given a means of naturalization after 12 years of residency in India. And then there were some events like in the 80s, the Assam movement, and other events like in 71, the refugees which came over from Bangladesh before the creation of that nation made us create some amendments in this Act of 1955. The Citizen Act was further amended in 1992, 2003, 2005 and 2015. In December 2003, the National Democratic Alliance led by the Bharatiya Janata Party passed the Citizenship Amendment Act of 2003 with far-reaching revisions of the Citizenship Act. It added the notion of illegal migrants to the act, making ineligible to apply for citizenship either by registration or by naturalization, and declaring the children also as illegal immigrants. So this amendment also mandated that the government of India to create and maintain a national register of citizens, that is the NRC, which again was vehemently objected because it seemingly seemed to be discriminatory. So seeing all this happen, the Amendment Act of 2019, what does it exactly say and mean? So this is an amendment basically by inserting the following provisions in section 2 of subsection 1 after clause B, provided that any person belonging to Hindu, Sikh, Buddhist, Jain, Parsi or Christian community from Afghanistan, Bangladesh or Pakistan who has entered into India on or before 31st day of December 2014 and who has been exempted by the central government by or under the clause C of subsection 2 of section 3 of the Passport Act of 1920, in which the application of the provisions of the Foreigners Act of 1946 or any other rule shall not be treated as illegal migrants for the purposes of this act. A new section 6B was inserted in the section with 4 clauses. That is, the first saying that the government or an authority specified by it in this behalf may be subject to such conditions, restrictions and manners as may be prescribed on an application made on this behalf to grant a certificate of registration or certificate of naturalization to the person referred to. The exempted classes of person were previously defined in the Foreigners Order 2015 under the Foreigners Act of 1946. This gave an exemption of certain class of foreigners, that is, persons belonging to the minority community in Bangladesh and Pakistan, namely Hindus, Sikhs, Jains, Buddhists, Parsis and Christians who were compelled to seek shelter in India due to religious persecution or fear of religious persecution and entered India before 31st December 2014 have been covered under this act. So exemptions were granted to northeastern regions of India in the clause 4 of section 6B. Then valid documents like the passport, travel document and others matter and has been taken into account. Then Nothing in this section shall apply to tribal area of Assam, Meghalaya, Manipur or Tripura. Nothing in this section will cover the tribal areas of Assam, Meghalaya, Mizoram and Tripura. And the inner line notified under the Bengal Eastern Frontier Regulation will also be exempted, has been included in this clause. So, what exactly is the confusion and the problem? After having seen the Act and the Amendment of 19, which had been vehemently resisted, it is seen that this Act has basically amended the Citizenship Act of 1955 to give an eligibility for Indian citizen to persecuted minorities who are Hindus, Sikhs, Buddhists, Jains, Parsis and Christians from Afghanistan, Bangladesh and Pakistan to those who have entered on or before 31st December 2014. The Act does not mention about the Muslims at all. So, it has been felt that it has basically been discriminatory for the Muslims and they are not able to give the documentations which are required and thus they are being treated as illegal migrants or immigrants. So holistically, if we see, there are rights and there are wrongs also. So it is for you all to think very logically whether they should be implemented or not. You can give your comments in the comment box below and please share this so that the right perspective of this act is spread out into the masses. So if you have liked this video, please keep following our channel. Jai Hind.